Welcome. Thank you all for being here. I'm calling the special meeting of the Town Planning and Zoning Commission to order on Thursday, December 18th, 2025 at 7 p.m., which is a different time than we usually start. My name is Jeff Kennedy. I'm the chair of the Woodbridge Town Planning and Zoning Commission. Other members of the commission with us tonight are TPZ members, Mr. Paul Schatz, Bob Wisniak, Ben Cherry, Jim Horowitz, Aaron Hoffman, and Kathy Hunter. Thank you all for being with us this evening. Kathy, can you please just assist us with who is being, for the alternate positions? Can you just mention that?
You meant Chris.
Chris, did I say Kathy?
Yeah, you did, it's okay. You're just a little nervous. All right, so based on the rotation file, at last meeting, Sarah Locke was up, and this meeting, the rotation first up is Kathy Hunter. And the only person that we have to seat for is Andrew Skolnick, who's recused himself.
How can that be?
Because I think Bob was up.
Yeah.
Chris,
In the spreadsheet you sent me, Bob was up.
Kathy was up last time, so I don't know how she can be now.
How was it up in rotation?
She wasn't up in rotation. I don't know if you've got a copy of it.
She was up twice. She was the time before and that. How could she be up a third time?
You want to pass this down?
Yep.
Where the asterisk are, it shows who's up in rotation. And so it alternates. So you were up in rotation at our meeting on December 1st, at which point you voted as well as Kathy because Mr. Skolnick had recused himself and Mr. Hoffman had recused himself. And at that meeting, Sarah Locke was not there. At our meeting on December 8th, in rotation, Sarah Locke was up next. She was not here, she was excused. We needed one person to vote, and that was while Andrew Skolnick was not here. And the next person, as we go around through the rotation, was Kathy. At this meeting, the first person who is up to vote in rotation is Kathy. At our next meeting, you will be the next
I
person
just
up in
can't
rotation.
understand that. It's 3 times in a row that she was up. It doesn't make any sense what you're saying.
And you have voted twice out of the last 3 meetings that we've had, and Kathy has voted 3 times.
The last meeting, you even said that one time I thought I could just comment on something, and you said I wasn't up and I shouldn't say anything. You even said that. So I don't know how you
And that
can
was
say now that I'm not up.
That
I disagree with you completely.
Bob, we'll note that. We do have a process. We'll have the attorney look at it. I'm sure it'll hold up. But we will note your objection to Kathy being seated, so the commission notes that. Chris will note it, and we will put it in the records. Okay.
But I'm asking you as the chairperson to
Sure.
look at it and to see that she was up 3 times. This would be the 3rd time in a row that she's been voting.
Well,
I don't see how that's reasonable. I just
well,
don't.
we have a town established process. I don't get involved in that, Bob.
Well,
and I'm not
somehow
gonna do it.
this established process doesn't seem to be to follow any order.
Listen, I know your objection to it, and so noted, and we can look at it after the meeting, but for now, Kathy Hunter's.
I just can't accept it.
All right, I understand you're on the record for saying that. Continuing, we are ably supported by Chris Sullivan, our town land use analyst and zoning enforcement officer. Also joining us by Zoom, he's on the owl, is the town attorney Nick Bamonte. Nick, can you hear us okay?
I can. Good evening, everyone. Can you hear me?
Yep. And also Mike D'Amato, our planner, who is seated over on my left. We are meeting in room 16 of the center building this evening. Our special meeting agenda is available on the town's website and has been properly noticed. This evening we are here to discuss and take appropriate action on the 3 special exception or special permit applications for 804 Fountain Street. That's the only item that we're working on this evening. This is the Town Planning and Zoning Commission's final meeting for 2025. Our next meeting is on Monday, January 5th, correct, Chris?
That is correct.
which is regularly scheduled meeting on the first Monday of the first month of next year. The public hearing for 804 Fountain Street and its applications is closed, and so the commission and its agenda will move right away to our work session. So the only item that we're working on this evening is the work session for 804 Fountain Street, which we will move to right now. Commission members have been reviewing the vast amount of materials for 804 Fountain Street that have come in over the past several months. And at this point in time, I'd like to move to members in our work session to discuss their thoughts and ideas on 804 Fountain Street. We do expect to vote on a motion this evening. Drafted for the commission is a draft motion for consideration that approves the 3 applications for 804 Fountain Street, and also drafted by our town attorney in connection with our town planner is a draft motion to deny the 3 applications based on the committee's discussion of their views of the material over the next little bit of time. We will then vote on one of those 2 motions. And Chris Sullivan will be taking some notes, and we'll be working through, and those motions will be finalized and signed off on based on our final votes. Okay?
Mr. Chairman, if I could just add briefly to the discussion.
Please do so. Thank you.
I'm sorry, did you guys hear me?
Yes.
We just ignored you.
Okay, thank you. So, as you stated, there are 2 draft motions in front of the commissioners. One motion to approve with conditions, one motion to deny with a framework for inserting reasons for a denial. In order to prompt ongoing discussion, the chair should entertain a motion. I think the way this could go is the chair can entertain a motion to either approve or to deny. Then discussion can continue, and if it's a motion to approve, the discussion can sort of go towards what conditions, if they're in line with the recommended conditions or otherwise. If it's a motion to deny, the discussion can speak more towards the reasoning for denial. But I think that's how you prompt the discussion.
All right, so you think we should make a motion? I'm going to poll the commissioners and see what they say, and then make a motion to go with deny or approve. Is that correct? If I have you correct?
Jeffrey, could you ask?
I mean, you need a motion and you need a second to then trigger the discussion.
So we're already in the work session though, so can't we start discussion?
Can we just discuss it generally, Nick, and our views on it, and, then move to a motion after that?
Yes, you can.
Yeah, as to try to sort of get a sense of your commissioners, yes, you can do that.
Yeah, okay, that's where I was headed with this, so, okay. All right, so Nick, we're gonna talk about it for a little bit, see what people want to do, and then what'll happen is after a little bit of discussion, we'll then move from one motion to the next, and then before the vote on that, we'll discuss what people want to put in the motion. Is that cool? Is that good? Sorry.
Very good.
All right. Anybody want to offer some comments?
Could you just ask them about that this thing approves up for the alternate?
I think, in the interest of a transparent, fair process, if we could maybe explore this a little bit to Dr. Wisnia's satisfaction, and maybe just to the common understanding of the commission.
Sure.
I have to admit, I don't fully understand the rotation and.
Got it. Yeah, that's fine. So, Nick, this evening Kathy Hunter was seated to Dr. Bob Wisniak, okay? Did you hear that?
Yes, I did.
And so that was in connection with our, with Chris Sullivan's record keeping and the town and the commission's process on that. So Dr. Wisniak's asking if you could please respond to that. Do you have any thoughts on that?
Sure. I think consistent with what I suggested at the last meeting is to whatever extent possible, we should maintain a makeup of the commission for ultimate voting purposes out of the group that has been in attendance, obviously, and is most familiar with the record. Dr. Wisnia and Ms. Hunter were seated at the last meeting. Really, from my perspective, it depends on, and what I've said is.
That's not correct.
consistent with however the town rotates.
Well, he said something incorrect.
It doesn't matter. You're not speaking.
I think,
All right, Nick, he was not seated at the
point
last.
is, whatever the town consistently employs in terms of rotating its alternate should carry forward here for the determination of whether Dr. Wisnia or Ms. Hunter is seated.
Well, I don't think we're being consistent, that's what I'm saying.
may
Well-
I ask, was there, I seem to remember possibly a wrinkle at a previous, on a single night, is it possible that there were 2 seatings?
Yes.
Maybe it's like
Yes.
a restaurant.
Yep.
So every single week, or every time you have a meeting, there is an alternate who is up to vote first. If they don't show up, or if they are not needed, it automatically moves at the next meeting to the next person in rotation. And this has been going on since at least 2001. And everybody's been questioning it, but
I
it's here.
understand, I
All
understand
right?
that by
So
date.
let me finish.
Please
So what
finish.
happens is that like at your December 1st meeting, Mr. Wisnia was up in rotation. Sarah Locke was not here. We needed 2 people to vote at that meeting because at one point Andrew had recused himself from the 804 Fountain Street, and so he wasn't there at that meeting. And then Aaron had to leave when we got to the Luciani application. So then we needed 2 people. So Dr. Wisnia voted, and then Kathy voted. At our meeting on December 8th, Sarah Locke was up in rotation. Sarah was not here. Going through this thing, my thing, the next person you move to is Kathy Hunter. We only needed 1 person to vote at that meeting because the only person who was recused at that point was Andrew Skolnick, who was recused for 804 Fountain. And then later in the meeting, he came and he worked on the POCD. So if you look at my tabulation sheet, a P denotes that Dr. Wisnia was present, and Kathy, being the next person in rotation that night, because Sarah wasn't here, she voted. Tonight, Kathy is in her normal position of first up to vote. If we had 2 people out, then the next person in rotation would be Dr. Wisnia.
Thank you. I understand the rotation by night or by day. What I don't understand is how multiple votes in a single night affect the rotation. Do they affect the rotation as published, or does this rotation by night persist and march forward regardless of who votes at any given meeting?
The way it's been done for the past 20 some odd years is every meeting, 1 alternate is up in rotation first. And if they are not here that meeting, then it goes to the next person. We don't go back to them. So that there's a logic to who's up at each meeting. Because otherwise it would be all over the place, because you have people who, this past year we've had vacancies, we've had people who have been unable to attend. And so that's, the way it works.
Thank you.
It's the way it's always worked.
I think I understand the procedure. I just haven't been keeping close tabs. It sounds like you have, and
I have,
I'll take your word for it. Thank you. Thank you, Chris.
and I've sent it out numerous times.
Any final comment on that, Nick?
No, I defer to Chris's representation of the routine.
Thank you, so do I. Okay, so let me ask you a question. The alternates can participate in the discussion, correct? We've done that for years, even if they don't have a vote, right?
No.
We have a lead.
No.
We have.
Okay. All right, so we have done, okay, we'll move on. Okay.
But we have, for the record, we have had alternates
Non-voting alternates have discussed, and
And I think it's gone both ways, to be fair.
it has, Paul, it has. We're gonna fix that, we're gonna have a better policy to align that up going
Make it
forward.
easier
But
again.
people have to, I, as an alternate, have talked when I haven't voted years ago. But, listen, we won't continue to dwell on that. I do want to move into the discussion and continue our work session on 804 Fountain Street. So does somebody want to bring up some issues regarding the application?
Does that mean I can speak?
Okay.
No.
Sorry. Paul, thoughts?
I'm looking through my notes.
Sure.
I mean, I could do this without looking at notes, so I'll start out by saying that when I read the initial application, I said there's no shot I would support this. And then the applicant made a presentation, I thought it was impressive, and I thought they made some really good points to it. So I said, you know what, this is, it's certainly, they've checked a bunch of boxes that were part of our regs. And I think they did a good job in their presentation. And then the intervener came and spoke, and I said, wow, those are equally as powerful reasons to reject the application. Fully understanding that we cannot take into account things from public comment, like schools and traffic, because they're not part of the criteria to rule an application, which I think most people don't understand. I do have concerns from Trinkus's report, and I'll tell you what bothered me the most. Trinkus spoke to us under a different application. He was on the other side of the discussion. And then we heard, and he gave a presentation here, and then we heard from the applicant that basically my interpretation was Trinkus was nothing but a glorified quack. And then I read his response to what I consider personal attacks, and I thought his response had credibility, and I think in the end, it comes down to, is Trinkus a credible expert in the case, which I found he was a credible expert in the case.
So Paul, just as this is actually, only tangentially of substance to these proceedings, but I don't think it's fair to characterize criticism of Mr. Trinkus or his record as personal attack. We did see a number of personal attacks throughout these proceedings, and that bothered me. There were deeply personal, specific, unnecessary attacks on character that did not have any substantive association with the matters that we were considering, in my view. Now, Mr. Trinkus was here as a paid expert, and experts have to be able to take criticism of their work. It's just, it's the nature of the endeavor. I have a hard time saying that Mr. Trinkus' testimony was, any more or less persuasive than the other information that was presented. It was not clear to me that his arguments clearly carried the day with respect to questions of stormwater runoff and drainage from the site. Is there anything that you could point to that you found particularly compelling?
So, I'm not an expert in the area, and I thought the applicant made a strong presentation. And then I listened to Trinkus' presentation, and then I heard the reasons why we should dismiss it. I mean, what bothered me was that we were basically told to dismiss Trinkus because the judge was critical of some of his work. I mean, you weren't on TPZ at the time, but he made an equally strong argument for an application in 2020 or 2021 supporting development and supporting the stormwater systems that were being proposed. So I find it hard to believe that, and there are plenty of activist judges who can do anything they want, it's their prerogative. But I didn't find him to be what I considered to be a glorified quack. I thought I consider his testimony to be of expert quality. And I went through the numbers that he sent subsequently. And you're welcome to disagree, but that's how I felt.
I think it's hard for a board of lay people, but we've been in this situation a few times, to adequately weigh through all the different data that comes through the commission with respect to people on environmental issues, traffic issues, and drainage issues. It's hard to do that. I don't have a background in any of those things, and I kind of see one point of view, and then Paul, to your point, and then I see another point of view. And it's a little bit tricky to land on one side or another, but each commissioner is free to do that. I know one thing that we have to do is be as specific as possible in any decision that we do make, but I think sometimes it's a little bit hard to come down on one thing or the other. I have a few comments about this project generally. The town of Woodbridge, Connecticut has not had in its past much in the way of any kind of apartment buildings or larger buildings. It's not in our past. We're more of a rural town. Up north we have Bethany, to the south we have New Haven. This is a town that I'm very pleased to say that I live here because 37% of the land mass is fully protected by different conservation mechanisms or conservation issues, and we have about 30% of our land is highly protected. That's what's published in the conservation report, I think from 2022, but in any case, that is something published on the town website, can be verified. About 1% of our land has some kind of affordable housing or a different type of housing condition or quality to it. This project, I see some good in it in that it adds some affordable housing units to a town that hasn't had any affordable housing growth in like 15 or 20 years. So we don't have a lot of affordable units in town, and we are in a state where the state is trying to encourage municipalities to do more of this type of development. So I know it's a large apartment building. It's a very large apartment building. I'm going to get to that in a minute. But this is an apartment building that provides units for younger people. It can provide units for older folks looking to live in the town of Woodbridge. And these are housing options where there are a few in a town that's mostly middle and upper middle class, single A residences. So this is a privately owned parcel of land. It's located right on the border of another town. I find some of the environmental comments that have come up persuasive, but it is right next to a major highway, and there is a lot of our town that is protected. This type of application, and with us working on it, and Dr. Cherry's addition of a second elevator to the apartment, which we went out on, gives us some say over what some of these buildings might look like when an 830G application, which we just got in town, does not, where the zoning gets a little bit more removed from these applications. So for me, Paul, I too, see the benefit of this building. What is a little bit hard is that it's a 116,000 square foot building, and with respect to our regulations, it is a building that, with respect to the harmony and appropriateness of the town it's in and where it's located, I see sensible objections to it at that size. It's a very, very large building, and there are very few of them in this town. I can tell you this type of thing is happening in a lot of locations in a lot of towns in Connecticut. We happen to have the first major application in a long time for an apartment like this. I get that. It's very concerning to people, but I think we need to give it a hard look before deciding for or against it. Paul, what are your thoughts about this based on what I?
Why are you always directing it at me? We get all.
Because you're the only one that talks. We're losing you at the end of the month.
I will say this, Jeff.
It's helpful to me, Commissioner.
I agree with you that it's hard.
Jim.
Right, I'm not an expert. I never said I was an expert. But I will say this, I really appreciate, more than I think the applicant would know, how willing Angela Malisi was to work with TPZ. So my view is if I were developing it in town, I would want to work with that kind of person who had the elevator, who was going to buy the ladder, who do a thing to do things to get it done. So I do appreciate that. He didn't try to ram it down its throat like perhaps other people have in the past. I do appreciate that very much.
Another consideration for people to think about, we did change the zoning regulations in town to try to see more options of different types of buildings because we have been seeing so little development for a very long time. So we did change and revise our zoning options. And so that made this particular building application possible to submit. I do feel it is largely consistent with the regulations, absent the special exception, language and items. Let me read these. Let me take a look at this. So in section 6.0, 6.3 special exceptions criteria include among these 7 items. This is on page 135 of our zoning regs. Those items include the location and size of the proposed use. So that's something that commission members can take into account when they vote on a project. Item number 4, the safety and intensity of traffic circulation on the site and adjacent streets. Number 5, the scale of the proposed site and structures. Number 6, the harmony and appropriateness of the use and site design in relation to the general area and to adjacent properties. So those are special exception qualifications that the commission can take into consideration in its vote. Our town attorney and Mr. Nuff have raised comments about, let me see Mr. Nuff's comments. When special exception language is being raised, there have been some law settled cases in the case of McLaughlin.
Mr. Chairman,
Yep.
respectfully,
Yep.
and with full respect to Mr. Nuff,
Yeah.
Mr. Nuff does not exist in these proceedings as a source of legal authority,
He does not.
or case law, or interpretation,
Yeah,
or advice.
Yes, keep
So
going.
if I may,
Yep.
his role in this matter is to convince us to accept, his interpretation vis-a-vis the law and the specifics of the application, i.e. to accept his version of reality. And he's performed admirably in that respect, but
Yep.
let's not cite his statements.
He brought up a court case, which I'd like to go to, as did our attorney. I don't know if that's in the record.
I would like to understand the attorneys and your interpretation. I'm not interested in Mr. Nuff's interpretation of the law.
I'm not giving you Mr. Nuff's interpretation of it. He cited a case that is generally cited. Nick, are you there?
Yes, I am.
So McLaughlin and P&Z Commission, Town of Bethel, are you familiar with that case?
I am.
And what does it say?
Well, it codifies a wealth of existing case law that talks about what substantial evidence is.
Okay.
And that in order for a commission to base its decision one way or another, there has to be substantial evidence, either that an application is consistent with the regulations or there's some defect. Substantial evidence has to be specific. It can't just be general speculation. Oftentimes, especially in matters of environmental concern, just public testimony isn't going to cut it. Expert testimony, this is more technical type material, so the courts look at expert testimony, favorably to more general public speculation. That's really the bottom line of what substantial evidence is, and I think that's what that case does a good job of outlining.
Thank you so much. So what I'm saying is that specificity, when it's employed by the commission in discussing these items and the town planning and zoning regs, is very helpful for any any post-decision actions that occur.
Thank you.
Absolutely.
Chair Kennedy,
Please.
if I may, I'd like to just read my comments into the record. And these are comments I provided to Attorney Bamonte as requested.
Sure, so overall, like all of your comment?
Yes,
Okay. That's
because
fine.
I
sure.
think it would cover some of the discussion that you're having.
Sure, sure.
Okay. So based on my review of the complete record, including the application materials, technical reports, and evidence presented during the public hearing, I find that the proposed development satisfies the applicable special exception criteria. I do not find evidence in the record demonstrating that the proposed use would adversely affect the public health, safety, or welfare, or the immediate neighborhood as those standards are applied under the zoning regulations. With respect to fire safety, the record establishes that the project is required to comply with the 2022 Connecticut State Building Code and the 2022 Connecticut State Fire Safety Code as a condition of issuance of a building permit. The evidence reflects that the building will include a sprinkler system, fire-rated construction, and emergency access on 3 sides, all consistent with applicable code requirements. No evidence was presented demonstrating that the proposed development as designed and conditioned fails to be applicable fire safety. With respect to traffic safety, I rely on written reports of qualified professionals, including the town's peer review conducted by VN engineers, as well as testimony entered into the record. Based on that evidence, I find that the proposed development will not create an adverse impact on the operation or safety of adjacent roadways. The record further reflects that the proposed side access and curb cut are subject to review and approval by the Connecticut Department of Transportation for adequate sightlines along Fountain Street, and the final approval of the curb cut is contingent upon DOT determination. With respect to location, the application is consistent with the town's plan of conservation development to the extent permitted under the zoning regulations, which allow opportunity housing by special exception in limited residential areas that are served by public water and public sewer and are located outside the public water supply watershed. The subject property at 804 Fountain Street satisfies each of these locational criteria. With respect to size, scale, and harmony with the surrounding area, the subject property abuts the city of New Haven and is bounded by Fountain Street, the Wilbur Cross Parkway, and property owned by the Woodbridge Land Trust. The surrounding area is sparsely populated and characterized by substantial open space. The size, massing, and placement of the proposed structure are supported by the site plans and supporting materials in the record. I further note the height of the building remains below the top slope of the ridge, and that the site's natural topography allows the structure to be set back and integrated into the ridge, resulting in a placement that is visually unobtrusive from surrounding vantage points, while providing residents with views of the protected West Rock Ridge in the city of New Haven. With respect to architectural harmony, the applicant revised the building design to incorporate elements consistent with residential development as documented in the submitted plans. My findings of compliance is based on the applicable zoning regulations, which expressly permit and contemplate design modifications reflected in the record, and not on subjective preferences or considerations outside the regulatory framework. Accordingly, I find that the nature and intensity of the proposed use are consistent with the Opportunity Housing Regulations and the purposes of the Zoning Enabling Act, which authorize multifamily housing for low and moderate income households in residential zones served by public water and sewer outside the public water supply watershed. With respect to the intervener's application, I find that there is no substantial evidence in the record demonstrating that construction of the proposed property is reasonably likely to have the effect of unreasonably polluting, impairing, or destroying the public trust in the air, water, or other natural resources of the state. The expert testimony offered by the interveners is largely speculative and is not supported by concrete evidence demonstrating a reasonable likelihood of environmental impairment arising from a residential apartment development of this type. In contrast, the record reflects that the applicant submitted substantial evidence demonstrating the project incorporates erosion and sedimation controls during construction, post-construction, stormwater management measures, a planting plan, and an invasive species management plan. With the implementation of these measures as reflected in the approved plans and subject to applicable permits and inspections, I find no substantial evidence in the record that the proposed development will cause unreasonable environmental harm to on-site or off-site natural resources, and accordingly conclude that the interveners have not met their burden of proof.
Thank you. Someone else like to jump?
Yes. It's with all due respect to Commissioner Hunter, and I know that we sat in and heard many of we heard the same testimony, we read the same evidence, and I would say that I have come to a conclusion that is 180 degrees in the opposite direction. The purpose of our zoning regulations, as stated in section 1.2, is to secure safety from fire and other dangers and to give full consideration to the character of our districts. And the fact that safety is paramount in our zoning regulations should not be underestimated. The applicant has sought a number of special exceptions, and 6.3.c of our regulations say that there are certain factors to consider for special exceptions, and those include safety from fire and other dangers as described in section 1.2 that I cited above. Also in our regulations, it talks elsewhere about the health and safety of the public, the location and the size of the proposed use, the scale of the proposed structure, and the harmony to the area. So that's kind of the framework for where we're starting from. In view of all of that, it's my conclusion that there should be no special exception for the roof. The purpose of our pitched roof requirement in our zoning regulations is to preserve the character and harmony with the area. No reason has been offered to grant this special exception. The purpose of the sought-after special exception is to put 96 air handler units on the flat roof. The fire department has been here, and they spoke at our last meeting very persuasively, that they have identified there are accessibility and safety issues for its personnel to access that flat, fourth-story flat roof. There was some discussion as to the amount of jump off that would be required because of a parapet that was added in order to obscure the flat roof from some distance away. The jump off required for the firefighters to access the flat roof was not identified by the applicant, and I find that omission to be striking. Also, the town does not have the equipment in order to access the flat roof where these 96 air handler units are going to live and all pose a fire hazard. In view of that, and in view of our obligation to protect the safety of the community and the safety of our firefighters, there is no basis to grant this special exception, and I think we'd be doing substantial harm to Woodbridge and our community and the safety of our neighbors if we were to grant this special exception. The traffic study that was done required the removal of a large quantity of rock ledge. It is clear from all of the testimony from all of the experts that in the absence of the removal of that geologic formation, traffic safety for both eastbound travelers of Fountain Street and people egressing from the 804 Fountain Street project cannot be satisfied. So I looked at the zoning regulations about this question of the removal of a large quantity of rock ledge. Section 5.9, section B2 indicates that to the maximum extent possible, site features such as rock outcroppings shall be preserved. This applies to trees as well. This, therefore, is an additional basis for rejecting this proposal. The affordability plan that has been mentioned. The applicant, who has indicated that they have experience in serving as an affordable housing administrator, a dual position with, strikes me, as an inherent conflict of interest, assures in its December 1st, 2025 submission, the sample deed restriction, that 12% of the units will meet criteria for affordable housing. Just for purposes of calculation, 12% is 11.52 units. The applicant has provided completely unsatisfactory explanation as to how it's going to satisfy this commitment. The applicant acknowledged that due to rising income of tenants, the number of affordable housing units rented to qualifying persons or families likely would fall below 11.52 units. Therefore, the criteria is not met. The number of units could go below 11.52, could go below 10, could go below 9, and there is no explanation, despite the claim of expertise in administering affordable housing units, that they would be able to address this problem. Therefore, another reason for denying the application. With respect to the intervener, there was a substantial discussion concerning Mr. Trinkus and his report. One is Mr. Trinkus submitted a report and submitted a response to the statements that were being made against him. A footnote in a judicial opinion as to an individual's credibility is not, under any circumstances, a basis for saying Mr. Trinkus's opinion should not be followed. That is not correct. It's not correct as a statement of law, and it is not a basis for us to be following that. Mr. Trinkus has vast experience in the state. If the court had decided that Mr. Trinkus was a charlatan, that Mr. Trinkus's testimony should never be followed, the court had methods and options to take care of being sure that Mr. Trinkus would not be testifying in the state of Connecticut. Clearly, the court did not take that approach. Mr. Trinkus's opinions and statements that he gave to us with regard to the environmental impact of this property and this development were sound, they were thoughtful, they were not to the satisfaction of the applicant, I will say that for sure. But they are credible, including the risk to Bishop Pond, the removal of that rock ledge would have to Bishop Pond, to the habitats that surround it, and to air quality. I find all of that to be credible. With regard to the intervener obligation and what we need to find, is there a reasonable likelihood of an unreasonable impact on the environment? Clearly, the answer to that question is yes. Are there feasible and prudent alternatives that could be followed, including smaller project, more thorough design, alternate location, lower building height? All of that says that there are feasible and prudent alternatives to this. The intervener's testimony and evidence presented to us is persuasive, and there is no reason for us to be granting this application.
Thank you, Jim.
So can we have a conversation about that? So
Yes.
last meeting, I think it was last meeting, the architect for the applicant explained that the parapet height had been lowered to 2 feet as a result of the roof modification. That seemed to satisfy the fire chief. Do you have a different recollection?
My recollection of that was that none of the people who were present could answer what was the size of the jump. Remember, I asked the question, I confess to not being a geometry wizard. But when you are putting a ladder up and over a 2-foot parapet, the jump is not going to be 2 feet. You are going up, over, and above the parapet. There's an angle. And what that jump is, I don't know. Nobody can answer it, but it seems to me that the person who should be able to answer it with regard to the safety for the firefighters is the applicant. Is it safe? And when you have 96 units up there, each one of those units representing a source of fire hazard, that's where the fire is going to happen. It's from those 96 air conditioner units. It is not up to us at this juncture, after months of doing this, to be speculating as to is the jump 2 feet, it's higher, more than 2, is it 6? A suggestion was it was less than 6, but what is it? We don't know. And because our obligation, our commitment is for the safety of both the residents, our firefighters, and the vicinity, that uncertainty is an uncertainty that should be held against the applicant.
I just think it's an odd double standard to invest the authority and the responsibility in the applicant to ensure that the professional activity of firefighting is able to be conducted. You know, that's not what they're in the business literally doing. And so my interpretation last week was that the fire chief was satisfied with the 2-foot parapet height. I think it's a misstatement to say it's the job of the applicant to determine that height and to make sure it's safe for firefighting activities.
So I think there's two parts to what you're saying. And I think it is important for us to be able to listen to what it is that the fire chief had to say. I do believe it is the burden of the applicant to provide us with persuasive evidence that this building can be safe. That is their job. And if this is a factor that needs to be considered, then it is up to the applicant in order to present that evidence. And safety, the safety of the building, the safety of the community, that's our job. The presentation of the safety of the building and to persuade us that this is a building that can be safely addressed is the responsibility of the applicant. What we look to the fire chief for is for data that will help inform us as to whether or not the applicant has satisfied their burden.
Well, we look to the fire chief for his assessment of the information they provided about the design of the roof. And my interpretation of his comments and body language was that the 2-foot parapet height, he said something very similar to, oh, that's a lot better.
I agree he said it's a lot better, but, and 6 feet or 8 feet as compared to 2 feet or greater, that the 8 feet would be worse, or the 6 feet would be worse. But what is that height? That evidence was not provided to us. That assurance of safety was not provided to us, and I do see that as the burden of the applicant and our responsibility to assure based upon the zoning regs.
I'm not following how that distance, something between, do you have a hypothesis about what that distance is? Is there?
So if this is the slope of the parapet, and this is the ladder, if the ladder has to come above the height of the parapet in order to provide the firefighter with access to the roof, it's just a matter of logic that if this angle is 2 feet, and the ladder has to get above that point in order for the firefighter to safely jump, it's going to be higher than 2 feet. It has to be. I mean, that's just basic geometry.
Yes, but you need to assert how high you think is unsafe in this context.
That's where I disagree with you.
Okay.
I don't have to assert that.
Okay, you say you don't have to assert it. You say the applicant has to assert it. I say the fire chief has to tell us whether it's disqualifying. He clearly indicated, in my view, that it was not a disqualifying height.
I respectfully disagree with that
So
conclusion.
you also stated that something about the removal of the rock was disqualifying, and you used the phrase to the maximum extent possible. I mean, does it not seem to you that the extent necessary to ensure traffic safety is included in that clause?
So what I'm citing is 5.9B2, which indicates to the maximum extent possible, site features such as rock outcropping shall be preserved. That's what our regs say.
And if that extent does not provide for traffic safety, so we simply wouldn't say, we'll sign off on a plan where the traffic safety has not been demonstrated. And so if it's necessary to achieve traffic safety and it's necessary to remove that material, then it should still be preserved to the maximum extent possible. But I don't find that argument compelling at all. Can you explain what should be preserved to satisfy your concern?
So the rock outcroppings are a unique geologic feature to our community. As you drive up and down Fountain Street,
The word unique is...
you may quarrel with what I'm saying, and we can disagree. I'm okay with that. I'm okay that we disagree. I believe that there are lots of people who have addressed this question of the geology of our community. There were submissions that addressed the geology of our community. There were submissions that talked about how unique and special the geology of our community is. When you drive up Fountain Street, you're struck. One is struck. Maybe you're not. Some people are struck by the geologic features.
I'm going 95. I can't see it.
There you go. There you go. So, but to the extent that one believes that those geologic features are part of our character, are part of the nature, of our community. I think that is what the authors of our zoning regulations had in mind when they said at 5.9B2 that to the maximum extent possible, features such as rock outcroppings shall be preserved. There's a reason for that. There's a reason for that. That wasn't just language that was taken out of thin air. And this is language that we are obligated to respect. And so are there places where we could have buildings that are of this size and this magnitude in Woodbridge? Perhaps, perhaps. Are there places where you're not going to be destroying the natural habitat or destroying the natural outcroppings? I can think of a lot of other sites in Woodbridge that would satisfy that. But when I take a look at all of these features, the roof, the safety, the fire hazard, the traffic, the affordability issue, the impact of the environment, when I take that constellation of factors and I put them together, that all says to me, this may be a good project, not for this place, not for this place. And we have at our disposal the regulations, the rules to follow in order for us to weigh each one of these factors and to make a determination as to whether the applicant has satisfied that this is the right place, the right project, the right time. And when I consider each one of these things, I reach the conclusion, and you may disagree, and that's okay. But when I hear all of those things and I put them together, to me, I reach the conclusion, maybe it's the right project, but this is the wrong location for this project.
I'm primarily concerned in any direction how any argument will be substantiated and defended. And I don't think that a comment about the maximum extent possible is a general comment about how we approach planning in the town, right? I mean, 59B2 it's how we're treating this application, is it not? I mean, so with respect to this application, with respect to this proposed development and the proposed special exceptions, it is incumbent upon us to protect to the maximum extent possible the natural features. But if preserving safety, with which this preservation is intention, requires the removal of a certain amount of material, then I think we're still, let me back up and say, I read Mike D'Amato, sorry, sir, you're relatively new.
Mike is fine.
To me. I read Mr. D'Amato's report, and I want to turn to him and Attorney Belanti in a moment to get more of their feedback and their point of view. I mean, I don't feel great about following a lot of things that Mr. LaFountain said to us a year ago, but I have to, at some level, avail myself of the expertise and experience of these folks who we've retained on behalf of the town. And my reading of Mr. D'Amato's report and his sort of reminders or suggestions to us about the specific nature and extent of our role and authority is that a statement like this, if we use this as a basis for denial, really needs to be well explained and defended. And I don't think that citing this to the maximum extent possible clause is a sufficient basis upon which to say we just can't have the removal of these rock outcroppings.
So here's where I think you and I are having our disagreement. I think that when you see the language, the maximum extent possible, you have in mind, and I don't mean to be pejorative or putting words in your mouth. Yeah, so that I get the sense that you're thinking is, what do we have to do in order to approve the project? And what I'm thinking is, when I look at these zoning regulations, when I look at the plan of conservation and development that we just voted on last week, and that we reviewed as it existed 10 years ago, I think about what is our role with regard to the larger Woodbridge community? That's the question. And so, is it possible for a developer to come in and knock down rocks and clear cut? And of course it is. Can they cut down trees? Of course it is. Can we eliminate all of the trees in Woodbridge? Of course we can. It's doable. Should we, as the Planning and Zoning Commission, and the holders of the of the mantle for planning and conservation development, should we just say, well, if a developer comes along and says we can knock down the trees and we can build all kinds of great stuff and we can knock down the rocks and we don't have to worry about rocks anymore, then I see that as an abdication of our responsibility. Because our responsibility is, yes, we have to have affordable housing in Woodbridge. 11 units that is sometimes going to get to 12% and sometimes not. That doesn't get us the affordable housing that we want. It just doesn't get us there. Do we need to do something? Yes. Do we have to educate our community that we need affordable housing and we need lots of affordable housing units? Yes, we do. This project doesn't get us there. If the developer comes in and says, look, I can build this big building, it's really cool, it'll make me a lot of money, me the developer, and we can clear cut some woods, we can clear cut some rocks, does that mean that we as the zoning commission and the stewards of conservation in town need to say yes? I just don't think it does. And I think that when our zoning regulations say to the maximum extent possible, they're not thinking about the project, they are thinking about the community.
I don't think that argument is compelling. You can't simply say that there's a clause in the zoning provisions and that we have to use that to think about everything else in town when considering the specific geography. You're making two arguments. You're saying we have to consider all the specifics of the site, and you say, no, it's not about the site. It's really about the general way in which this phrase applies.
It's both.
But moreover, I don't think that you correctly stated the role of this commission, and I'm drawing from Mr. D'Amato's report. I don't think that our role is to decide whether to approve this based on our sensibility about these certain things. Of course, we have to think about the special exception criteria. They've been front of mind since the beginning of this process. I think because we've been described as quasi-administrative and quasi-judicial by Mr. D'Amato, that we have to clearly articulate the basis for our decision in either direction. And, that I also don't agree with your characterization of that clause and its meaning to our role and the broader sort of mandate. This clause is saying a developer can come in and say, we're just going to flatten every fraction of an acre of this property because we own it and because we can. It says that natural features that are important to the property and to the town must be preserved within sort of the framing of a project as a matter of principle and as a matter of regulation. Not that certain sites are completely off limits because of their unique environmental features. That was the argument the interveners made. We haven't quite gotten to that. But I just, I think we disagree on that point. With respect to, the affordability, I agree with everything that you said about that. The problem is the time to act on that was 10 years ago or more. I'm not taking shots at anybody, at any leader, at any party, at anybody in this town. I've only been in this town for 8 years. I hope I'm here for another 48. But educating our neighbors about affordable housing, the time for that was long ago. I mean, look at where we are in the history of the state. Look at what's happening in Hartford. Look at what's coming out of Hartford. It does not affect my calculus of this application, but the 830G is very much on my mind as I think about this town and planning in this town. And I agree with everything you said about affordability and thinking about more creative ways to improve access to affordable housing in town. But I don't think that is the basis for saying that this is not going to do enough. Mr. D'Amato said that the shifting nature of the possession and identification of affordable units is just kind of a weird thing that is not settled it's not settled in our regulations, certainly. There's no prescription for how it should be done in our regulations. I didn't hear of any prescription in state law. I'm sure that somebody could have told us whether there was a prescription in state law. So there's no statutory prescription about how that's handled. There's nothing in our regulations that says how that's handled. I don't see how that could be a basis for denying this application.
So, Ben, maybe, I appreciate this give and take. I think it's been really helpful for the town. I think we sort of know where Jim's position is going to be. So I appreciate your critique. Maybe you could share with us how you feel about the project overall.
I don't think that's helpful to anybody. My feeling about the project overall is not what I'm here to do. I'm not here to tell you how I feel about the project.
All right, your thoughts and that, I strike that, your thoughts, which is a better word, so that at some point we could come together on making a motion.
I'm having a really hard time concluding that the interveners met the bar that Attorney Belmonte articulated.
Sure.
And I'm also having a hard time finding a specific place in our special exception, criteria for consideration that would allow this to deny this project. Part of the reason I'm asking, to go through each of these assertions that kind of comes up is because I want to really understand them. I would like to be convinced. I want to understand because I want to reach consensus and I want to, vote my conscience based on my understanding of information. And I may not understand something. So that's part of the reason I'm going through these point by point.
May I, as a point of chair order?
Please.
I always like consensus. It's really hard to achieve, and that's not likely going to happen on a project of this magnitude.
Maybe
but I
consensus
like
is
you
wrong.
trying to go towards that.
Yeah, maybe consensus.
It's
was
healthy
wrong.
for the town and is good for everybody involved, but it's probably not going to happen. Would you like to think about your thoughts a little bit more, and I can call on somebody else to contribute for a few minutes?
Sure.
Okay, Aaron? Of course.
I appreciate all the conversation that we've had on this tonight. Everyone has obviously put a lot of thought into this, and it's not, in my view, a clear decision. We are weighing impacts of the development on the town, and we've seen reports that, the traffic report basically says that it will not have a substantial impact. But obviously, if you're stuck behind someone on the hill, and we've dealt with this in other projects, that, people's feelings about traffic in town, are not well captured by engineering reports, even though that report is, uncontested by experts. So obviously there will be more cars in our community by some measure, and there will be fewer trees by a definite measure, and there will be impacts on the town. And to say that there's no impact, or it's negligible, or we're making trade-offs. And I guess my comments on the larger process, I do really appreciate over the last month and a half, we've taken in information, and then prior to that, and then we were able to have a more direct conversation about the project. And it's disappointing to me that we were not able to start that from an earlier point. And part of that is just we're hamstrung by our regulations. We were hamstrung by turnover in the town planning position. We were hamstrung by the fact that it was an election. And that entered in my opinion, a lot of, it complicated the matter in ways that I don't think were productive. I do think that there is, and I don't know how we change it going forward, but the developer, the applicant seems to have been willing to work with us, and I think the process would have been more satisfying to the town as a whole and to us as a commission had we been able to do that on an ongoing basis from the beginning and have more of a dialogue than we were able to. And we have to weigh the impacts, coming back to it, of development. There are impacts, but I think there are benefits personally to having a development like this. There are, we as a town, there will be families that the development will pay taxes, some of that will go to the school. We are in a unique opportunity now when almost everyone in town agrees that something needs to happen with Beecher. We have a unique opportunity to think proactively as we are looking to the future of Beecher, so we can welcome more families to the town. As we look at an increased population in town, we can attract more businesses, we can try to have more restaurants in the flats that stay open, we can attract, we've had some new markets that open. I want the town to succeed, and there are trade-offs that, in my opinion, may be worth it. I really appreciate the thought that the other commission members put into their reasonings for and against. And it is not an easy vote in any, at all. I've put a lot of thought into this, but I do also agree with Ben that we have a prescribed role. I probably shouldn't have even brought up the school, because that is not one of the things that we're supposed to inform our decision. But obviously, hundreds of people talked about it, so it's something that everyone has internalized and is front of mind. But I thought that our town planner's report was persuasive, and that and I believe that has met the burden that we as a commission are required to follow. I'm happy to discuss anything further.
How do you feel about the size of it? It's 116,000
So that's one of the,
feet.
the square footage is.
So in tying to like the special exception,
Yeah.
which is, that's not anything in the neighborhood or nearby,
Yeah.
it's a larger building. Now, when you drive up Fountain Street, based on the plans, the more narrow side is what's facing the street, and the length of the building, is opposite of that. But it's 116,000 square feet, which is the size of 2 super grocery stores. So it's a very large
It's a big building,
building.
100%. It's a big building, and it's one of the things that possibly we could have discussed if the process were different, was looking at the massing. And I think it's too late to do that, but I would have been very open to that conversation at the beginning. It's a big building, but when we're looking at the impacts of, just say, if at some point during the process we said, will you please lop off a story? It'll be 3 stories, and the impervious surface wouldn't change substantially. I guess you'd have some decrease in parking, but there would still be, the amount of rock removed would still be the same. I think that, the alternatives there are not, it doesn't, as a reason for rejecting now, because we're past that negotiation, I think that it's a big building, but it's also in our zoning regulation allowable. And you can disagree that this site particularly is appropriate for 4 stories. I wouldn't begrudge anyone for saying that it's inharmonious. My opinion is different, but if, it's aesthetics, it's of what you are willing to say are harmonious. But I do believe that there are places in town where 4 stories is reasonable, and that's one of the reasons why when we went and made that change, that I thought that was reasonable, because I think it's reasonable here. I also think it's reasonable in some other locations, and so, but if it were 3, maybe it'd be better. I'm not, but it's 4, and that's what we're voting on. So
Let me help you one thing.
Yeah.
So I agree, with the 3
Yeah.
or 4 stories, and I find, 3, more compelling. It sounds better. It's more compelling. It's a smaller building. At the same time, when a town does a very high density development, even if it's very impactful in the small area that it's in, you're putting a lot of units and getting a lot of living out of that space. So you're maximizing, the number of people that can live there in one ground space within town. So it's a smaller space.
yes,
And what I want to try to do is conserve the town's areas of building. So you get a lot more, yield, if you will, if that's an okay word to use,
Yeah.
with the 4 stories in the frame.
Yeah, no, I mean, I think.
But I get your point, it would be more consistent with 3.
But I don't know that 4 25-unit buildings scattered across the town would be more favorable to, as an alternative, would be would be favorable to the community.
Right,
Um,
right.
Can we return to something you said, Aaron?
Please.
In specific, I mean, I think, I'm not asserting that any of you are confounding these issues, but I think in the public discussion and a lot of the testimony that we received, there has been some confounding of the zoning regulation change that we made a year ago, and this project in particular. I mean, I'm on record at this point saying I would not have approached that zoning regulation change the same way.
Yeah.
And, you know, I might get deposed for saying that by another party who's interested in what's going on in town. But I think, this is what I return to, and this is what I've been sort of agonizing over, is we made the zoning regulation change. It was on the books, right? This application followed it. So I think, I mean, my understanding of our role, of course, is to consider all of the special exception criteria, of course, to consider everything the intervener presented, and, you know, or maybe, but to chiefly consider the question of whether this is consistent, you know, with our zoning regulations. And I would like to ask, I mean, you know, Mike, you're not voting here, but I read your report as attesting, based on your expert analysis and you know, experience, that the application is largely, it is consistent in the ways that matter with our zoning regulations and with other sort of, you know, factors that we are allowed to consider in this matter. I don't want to put words in your mouth, but can we turn to him?
Yes, you can ask him a question. Yeah, he's staffed, so you can ask him a question.
So, I think I mentioned it at some point in my report when I was speaking to you, but, you know, in my role as a planner, I'm analyzing a portion, maybe a substantial portion of the application, but not the application in its totality, right? I'm not a traffic engineer, I'm not those specific experts. But when I review the zoning regulations and my understanding of your role in the context of the zoning regulations, I do believe the application is largely compliant with what is there. There are some things that I think, just in the discussion, that I want to point out in questions that were asked of me at the last meeting, and I'll just work into this. So I included the section about special permits or exceptions because there's a belief a lot of times amongst members of the public, commissioners, whomever, that when it's a special permit or a special exception, you sit there at this place of zero and you get to make a decision as to whether or not the applicant has convinced you one way or another. And that's not really the case. A special permit or special exception is for a use which you have already determined is allowed in the zone based upon the criteria you have established. You go through the process to determine if there are modifications or conditions to that application which you need to apply to make it more appropriate given the context of that specific development in that specific location. So it is not an arbitrary sort of yes or no. It is, we've already decided that this use is allowed in this place. But are there things we got to do to the application to make it a better fit? And the converse of that is with a site plan or a subdivision, you don't modify those. You approve or deny. So it's not just this arbitrary approach. So there are components which I don't have the technical expertise, nor would I say someone has or has not met, and you may decide however much weight those specific things carry. But you know, the other thing that I think I want to mention, because it seems like a lot of people are thinking about this, is that there certainly is, I'm trying to figure out how to say this neutrally. Different members have different perspectives on how sort of closely you sort of zoom into this project and analyze the context of what the regulations say and what your charge is, right? There is a line there, and you have to, I guess, kind of as a body, figure out exactly where that is. But one of the things that I would kind of come back to, I mean, the reason we're all doing this, right? The whatever 1925 case that established zoning is to protect public health, safety, and welfare. And so there is that line, and so, you know, there comes a point where we're kind of going beyond what is promoting public health, safety, and general welfare, and moving into something that I think is not sort of affecting the public, right? You're looking at things at a little bit of a larger scale. So I don't know if that helps or makes things more confusing, and I turn to Attorney Monti if I mischaracterized anything, but.
Well, I don't want Nick to state an opinion on the record if he has to continue being an attorney in this capacity. So, I mean, you know, if he wants to clarify anything that you said factually, but I don't want his opinion about this application.
No, yeah, sure. I don't know if there's any specific questions you have or things that I didn't answer or.
Nick, could you please summarize for us one more time? I mean, you essentially divided our consideration into two major components. The first is the consideration of the intervener's position and claims, and the second was the but our consideration of the special exceptions vis-a-vis our zoning regulations and the standards for granting a special exception. Can you please run us through one more time, specifically the intervener part? I mean, I think I understand our regs pretty well.
Yes, I certainly can. So I think what you're referring to is the framework draft motion for denial that's in front of everyone, and the sort of buckets under which this commission could potentially deny the application. The first is under the separate environmental intervener standard under section 22A-19 of the general statutes. So because we have interveners who have come into this proceeding under that separate state law, what that law says is if the interveners have submitted substantial evidence that supports that, and here's the statutory language, it is reasonably likely to have the effect of unreasonably polluting, impairing, or destroying the natural resources of the state, then that is your threshold question to answer with regard to the intervener standard. If the answer to that is no, there's no unreasonable impact, the inquiry ends, and the intervener standard no longer is a justifiable grounds for denial. You need unreasonable impact, and then if you do find unreasonable environmental impact, you need to take that one step further in order for legally this statute to preclude your approval. Step two is, okay, we've established there's an unreasonable impact. Step two is, are there feasible and prudent alternatives to the proposed construction? And if there are, so if there is an unreasonable impact, and there are, or is a feasible and prudent alternative, what this separate statute says is, if the answers to those two questions are yes, the application must be denied, because this conduct unreasonably impacts the environment. That's one bucket, one category, grounds for denial. The separate grounds for denial falls under the scope of your own regulations. And the way that we've represented it in the draft motion is on that second page, which speaks to the more general, broader public health, safety, and welfare standards that we've heard discussed tonight and at prior meetings, specifically section 6.3C. There's a placeholder for any points that would be built into that sort of a motion. And then there's another placeholder in item number 6, if there's any other sections of the regulations that the commission feels has not been satisfied, then that's a place where that could be inserted into this possible motion as well. In addition to the draft motion to deny, obviously you have a draft motion to approve with about 3 pages of conditions that might in large part reviewed at the last meeting. The only change in the draft motion for approval, I'll let Mike speak to it a little bit further, but on the question of the affordability plan and the permanency of units question. Mike, do you want to just touch on that quickly? But otherwise, I think I've answered the question, but happy to come back if need be.
Sure. You want me to do that now? Okay. So we talked about this at the last meeting and even prior to this, but since then I have read at least 6 or 8 affordability plans done by different projects all over the state, different attorneys, different everybody. And the idea, this idea that we're talking about where somebody may not, will become ineligible for remaining in the restricted unit it's commonplace. There are dozens of ways that you can sort of approach the wording in the affordability plan itself, but the idea that there is an opportunity for the operator and the tenant to have a discussion about what to do, and that there be some runway where perhaps that unit gets moved to another place in the building so that that person can stay in their residence is pretty much in every other plan that I read. Certain plans call it out a little bit more clearly. Certain plans, are sort of in more legalese, but I think that it's important to note that they still are required to file annually something that demonstrates they're in compliance. So this idea that this could persist for an extended period of time could not be the case. The town has the authority to take action and enforcement action against them if they are found not to be in compliance.
So what's the remedy?
We would initiate an enforcement action against them. It would be a violation if they said, here's our report, only 3 of the units are, we only have 3 restricted units. That would be a violation of the affordability.
Understood, and the remedy would be?
The town
can
could
do it.
commence an enforcement action against the property owner. But, so there's a couple of different ways that it can be specifically addressed in the language within the affordability plan. If you look at the language within my motion, I'm suggesting that the commission consider, if you include that language, this 25B, it would give the town attorney the ability to review to make sure that the correct language is in there rather than wordsmithing it here. But the idea is that they have the opportunity to move that unit to another place in the building. They have to demonstrate what units are restricted when they file that report annually. There are some places where there's a specific time frame within the affordability plan. So, they have a certain amount of time to actually establish what that would be. But the long and short of it is, every plan that I read provides for this thing to happen. And for many units to remain unoccupied, many restricted units to remain unoccupied, you would have to have a situation where that small number of units, there are no eligible persons that would be able to occupy the unit. I mean, that's really what would have to happen, because the affordability plan and there's the components within it require that they market the units. They can't just say, well, we're just going to leave them vacant, right? There's components of the existing affordability plan that require that they make the units available. They have to endeavor to fill it. So they cannot just say, sorry, we tried. We put a sign on the flagpole out front, no one came. It also means that they would have paid to construct a unit which they are not taking rent for. And so we covered the town of Bethel, which has had substantial 8-30G applications, substantial affordability plans, and many other towns. I've probably reviewed 3,000 housing units in the last 18 months. And this language is standard, and the issue of units going unoccupied really doesn't exist. It just, in reality, doesn't
So is this
happen.
treated, differently than an 830G application that requires a housing authority or an equivalent?
In what way?
So at an 830G, as I understand it, there has to be established some kind of authority, like a local housing authority, to determine exact, and to oversee what you're talking about.
There's someone who would be an administrator of the process, but it's not a housing authority.
So this is different than an 830G.
There will still be someone who will have to administer that and will have to verify the income of all the occupants, and will have
And
that.
it won't be the applicant, it'll be someone from the town? Is that what you're saying?
It could be a third party, it could be the applicant. There's nothing that precludes it from being the applicant. It will not be the town. That person is going to have to go through the financial statements of every tenant, and annually is going to have to verify the income of all those people, and then vet the people that apply.
So a third-party accounting firm, for example, could be appointed by the town, or?
It would not, the town would not be involved in who that person is, or who
So
that agency.
who would pick that agency?
The property owner would pick that
And then
agency.
they send it to us and we get,
And their,
as a town.
right, their role is to administer those units in accordance with the affordability plan that per the regulations is required to be reviewed by town staff and the attorney, and then filed on the land records, along with deed restrictions and everything else.
Understood.
So they will come to us annually and say, here's how we're meeting the regulations, and then we will verify that information. But we don't go and vet the financial statements of, the private residents within that building. And a housing authority would only do that if it was a housing authority project.
It's my understanding that on 830, sorry, we're getting way off topic, but 830G, there has to be an administrator. That can't be the applicant. So this is different than that, because here you're saying the applicant can be the administrator. Is that correct?
I am not aware of anything that will prohibit a building operator or owner from vetting and doing an analysis on the eligibility of a tenant, no matter what type of application it is.
I think some of the lawyers would disagree with that, but that's okay. I just want to thank you. I appreciate the information. Thank you.
I can just add to that, actually. So, Paul, just to clarify, this application is clearly not submitted under Section 830G, which carries with it a whole different set of legal standards of review. What is similar, though, and I think what you're referring to, Paul, is the framework for how these units are deed restricted, and then how the affordability is confirmed and validated on an ongoing basis. Under 830G, it lays out a very similar setup where an affordability plan, like we have here, and what your housing opportunity regulation also similarly requires. I'm not aware if under 830G there's actually an express preclusion that the applicant serve as the administrator. Oftentimes, in my experience, that role is served by a separate property management entity that is effectively an agent of the owner-developer, but as Mike explained, serves the legal purpose of each year sending certification that they have gone through the rent rolls, and they are confirming that the number of units that are supposed to be filled by an eligible occupant have been for the year in question. I mean, that's something we commonly receive in other towns where there's these similar types of applications with reporting obligations. So here, sure, can it be the applicant owner submitting those certifications or a separate entity? I think it could be either or, but the bottom line is that certification has to legitimately meet the regulatory requirements, or like Mike said, they're out of compliance with, if there ever is a permit approved. If they're out of compliance with their approval, they can't operate. And it subjects them to a formal zoning enforcement action, which could include litigation.
Can I
Please.
make a comment about there's been comments about the low level of affordable units, which obviously is in line with our regulations. And I believe this town needs more affordable housing, and so if the percentages was doubled or tripled in this, that would be okay with me as well, and it would maybe be a benefit to the project. But also, I do think that you have to look at affordability within a town, and the fact that if you are increasing supply, that has effect on price. There is not a lot of turnover of housing in the town, from my experience of looking at Zillow. And that's for a lot of different reasons. Some of that is because we locked in at 2% mortgages, but some of it is that people presumably looking to downsize can't. If they don't want a house, maybe they could move to the Toll Brothers thing, but that, and this was even taken into account in something that we read, but there will be some amount of people, some percentage, that may decide to sell their house and move into this apartment building, and that will increase the supply of units, and will have some, maybe it's not a significant effect, but in general, the increasing supply of housing does have an effect on price.
And I think we also need to recognize that this is the first time we are having the creation of affordable housing units since 1990, when we had 30 units of affordable housing constructed. So even though it may not seem like a lot, it's an increase from 30 to now 42 units, which is relatively speaking, is an increase of affordable housing.
Ben, some more comments?
I mean, I just keep coming back to what are we actually trying to decide? I mean, these ideas and hopes are important, and I can understand how they circulate in our minds, but, we're not considering this application for how it affects the denominator or the numerator of affordable units in this town. I mean, we made a change to the zoning regulations. I think that, that allowed this application to proceed. I think that the majority of the discontent among the people in town actually has to do with that zoning regulation change. I certainly listened very carefully and took a lot of notes on the public comments about this, and I found some of the arguments compelling, and it's part of the reason I engaged in a dialogue with the applicant and his representatives about some of those. But I view this as we have to meet a bar if we wish to deny this, which I haven't heard. Respectfully, I just haven't heard clearly articulated ways in which we meet those requirements. I've heard, very clear and specific examples about opinions from commission members about, the specific, substance of Mr. Trinka's report and his response. I just don't feel qualified to say that the information that he provides as the expert is so much more, credible. I mean, this, look at how technical this gets. Like, the reduction in total suspended solids and phosphorus and nitrogen. And has anybody here ever performed the Schuyler equation? I mean, it's very difficult for me to adjudicate the accuracy, not the veracity, but the accuracy of the information he's provided, or his assessment of the applicant's information. And so it's hard for me to say that clearly one of those arguments is better than the other. I do have to lean on our staff. And I have not heard a clear assertion, other than just sort of a general assertion that we find Mr. Trinka's report to be compelling because we find him to be professionally credible, that, what would the specific basis for denial be? I just haven't heard that. And as I sort of, as Jim and I had our exchange, I think I didn't hear a specific, argument in there that actually rose to the level of,
Can I give you a few thoughts on that?
Yes.
Because this is helping me,
Please.
all right, just by talking out loud about it.
Yeah.
He's helping me, Paul, so he's the
Good
new
thing,
Paul.
John.
He's the new Paul. So, look, 100 units of any kind of designation is not going to statistically change anything in the town of Woodbridge, Connecticut, okay? 100 units of anything. When the applicant first, we have not had a lot of building of any units in Woodbridge for some time. When the applicant came into the commission, they were okay with just a very small sort of spot zoning change to the very small area of that parcel rather than something more comprehensive. And that's what, when they first came, Paul, does that ring your bell? Do you remember that?
I think we would have
You know, so the
specifically-
applicant was sort of like.
We would not have said spot
and we-
zoning, but right.
No, it's okay to
It was.
say that. I know people fight about,
It
but we
was
get
spot
this.
zoning
It was.
initially.
Yeah, I'm in favor of that type of thing, and that would be controversial.
Sure.
All right, Sheila's gonna have a great newspaper publication in a few weeks here, a couple of weeks. Listen, I'm in favor of doing some types of things like that in a small town, but most people aren't, and people fight about it quite a bit. It's on the agenda for next January to relook at that broader movement that we had, all right, to relook at that. Now that it's a smaller town, we've seen that, because this is, you know, 4 stories and so forth, and therefore it's coming in as more, in my view, been highly compliant with the regulations that are in existence, okay? In my own mind, and I have turned this over like dozens of times in the past few weeks, I'll be glad when it's done this evening. But in my own mind, what I thought about this is it is highly compatible with our regulations, but the thing that I had the most difficulty over was the size of it, that it was a very large building, that it had a large, you know, sort of bulk quality to it of 116,000 square feet and the 4 stories and so forth. But we've done nothing in Woodbridge to add any kind of housing for people that own big houses in Woodbridge that want to continue to live in our town and that could rent a smaller place and stay in Woodbridge. We've done nothing to help people that are young, that want to get into Woodbridge and then buy a house in Woodbridge. When Paul retires and sells his house, if he had people in that building that would then go buy it, you know, that type of thing. Our town isn't functioning that way. We're not giving workforce housing. We're not giving enough help to people that are older and younger. So to your point, Ben, I do find these regulations largely compliant. The scale was something that I just had a hard time with. But this evening has been very helpful to listen to people here. I am an environmentalist type guy. Okay, I don't want to cut down any trees. Okay, but we have to do some building. We have to do some things that will help this town.
I think many, and
Does this help you at all?
well, no, I want to be really respectful when I say this, but I think a number of the things that you just said and a number of the things that, you know, that Aaron has said really are arguments in support of the zoning regulation change we made a year ago, that not the consideration of this application. And I think it's really important to separate those things, because my vote is going to be based on what we are supposed to do in this moment with this application,
Yes,
right?
yes,
It has nothing to do, you know, it's,
yes.
I'm thinking about history, but that's not factoring in, you know, when thinking about how we're handling this application. The zoning regulations are on the books. Our mandate is to consider this application vis-a-vis the zoning regulations.
Yes.
We are sort of administrative and quasi-judicial in the sense that there's sort of like the burden of proof is on us, and I may be mischaracterizing this. You know, Jim, I think you had a slightly different formulation. It seems to me that the burden of proof is on us to demonstrate that the application is not consistent with our regulations, or that the intervener has met, you know, the burden of evidence to support their claim. I just can't get there. And all these other points that you're raising, I think, are important. The school's in my mind, you know, the history of you know, affordable, you know, housing development in the town, but they do not directly impact the way I'm thinking about what I have to do here to defend my vote.
Understood.
Do you think, and my view I think is clear, so I'm the devil's advocate, do you think that you would not be able to say, I think this building is too big and like, so it's out of harmony and it's not appropriate? Just from that, because we're going to talk about reasons for whatever we get to the amendment, and so is that, and because I have my reasons for it, and I think it is harmonious, but that's a subjective, I'm agreeing, I think all the other things would outweigh that, even if it was, I'm not sure what I'm saying.
Yeah.
But so I'm asking you, is that, how do you feel about that? Because that is, you know, I want to make sure that we're talking this through.
Yeah, I mean, I think I didn't agree with everything that Kathy said, Commissioner Hunter. I did think that her description of, the specific location within town vis-a-vis the other sort of surrounding entities made sense. And that's kind of how I was thinking about it a year ago. Oh yeah, this is interesting. This is wedged between two state highways, right? In a part of town where there's not, for example, time of day huge spikes in traffic, for example, related to the school, right? I think if this building were, on Beecher Road, a half mile north, I would have a significantly different view of the location and size of the proposed use. And so, yeah, it is a judgment call. I mean, I think that's a place where my judgment is that, this is a part of town that could support this use. But I understand that that's a judgment call where people have different points of view.
I don't know where size, I mean, you guys are arguing like size matters, but if the regs are the regs, so I think that part's an irrelevant part. I'm surprised nobody else is concerned. Those folks living downhill from the project on the other side of the Merritt Parkway, we already know they get some water.
Yeah.
And we heard from Trinkus, we heard from two ecologists. I mean, somebody said it during one of the hearings that, what if the applicant's experts are wrong and it causes, undue harm to below? And you're a doctor, right? I'm like, do no harm. And my worry is, when you read Trinkus's report and from the ecologist, I'm like, I think there is a reasonable likelihood of a problem, especially for those folks living downhill. I know, and none of us are one of them.
But I do think that, I'm sorry to interrupt.
It's
I think
fine.
there's a remedy. So two things. One, we have two expert reports, and so they seem to be opposed, and I understand but what if Trinkus is right, and and obviously that's something we have to weigh, but I don't think legally you are allowed to dump water off your property onto a neighbor. And so if they start flooding, and I don't know, maybe our attorney can, if they start when the building goes up, and we're getting the same amount of rainfall, and the neighboring properties are flooding, and it's clearly because this building went up, that seems like that would be an actionable, and they would have to go in and triple their stormwater detention and spend millions of dollars fixing it. So it doesn't seem like, I understand, I don't want anyone, my basement floods, and it's terrible, and I wouldn't wish it on anyone, it's an incredibly stressful thing, but there is also an incentive for the developer to get it right, because I think that they subject themselves to significant liability if is the case. I mean, the other thing is that the Merritt there drains off the side of the Merritt into no sort of detention system. And you have, coming down towards the tunnel from, there's our neighbor Orange, and from that way, there's a lot of runoff. That area is subject to a lot of runoff. And so it does seem like that system that they've designed, but then, we have two experts telling us opposite things. So again, I'm not begrudging you that you find the intervener's expert more persuasive. We have to weigh the evidence. But I don't think it's they accidentally screwed up the calculations and now, New Haven has to live with it for the next,
Any more thoughts?
Yeah, I mean, I don't think, again, just, you understand the core of my concern and operating principles here, but I just don't think the question, what if, the intervener's expert is right, rises to the level of a reasonable likelihood, right? That's the standard. A reasonable likelihood of unreasonable impact.
That's a matter of interpretation, right? We trade the same,
Absolutely.
we trade the best of our abilities, we have different conclusions.
No, and flooding the neighbors is unreasonable, so that, I agree there, but where I think it's not a reasonable likelihood of them doing that. But if you believe it was reasonable, then, I'm just gonna say reasonable, unreasonable. If you believed that that was reasonable, then the next part, in my opinion, is reasonable, unreasonable.
I think I
Do you
got
understand
that.
what I'm trying to say? Is that, yeah, I'm not trying to help you make your decision. I guess I am trying to help you to make your decision. I want our all decision to be well discussed, and so that's why I'm kind of happy to go back and forth on those.
We would need to cite a specific unreasonable impact to the environment by certain proposed construction. I mean,
Yeah, and I don't think we've gotten that burden, but you could say that I don't believe applicants engineer at all, and so therefore the runoff will be unreasonable. Or I believe that, I don't believe that the site has particular geologic or importance. There is a lot of rock in this town, and I like it, and I really do. My kids were climbing all over it, and it's great. But I think the benefit of disturbing some of that rock outweighs the cost of saving it.
I mean, the intervener's geologist said, and I'm not aware of another expert that gave a specific opinion on this question. The intervener's geologist said, this is absolutely quite a special, maybe have even used the word unique,
The green schist?
ecological site. There's material here that doesn't exist elsewhere. There's a special phenomenon of, sort of repelling invasive species that we don't fully understand, but it further attests to the special ecology of this site. And, when I asked him, please bear with me and try to help me understand the consequence, of destroying this, his answer was loss of geologic diversity, essentially, right? I mean, that's what I recall from our exchange, and I don't certainly wish to mischaracterize his expert opinion, but that was what I got. And it's really hard for me to operationalize that into a specific unreasonable impact to the environment, right? So that's what our attorney has provided for us. We have to cite expert evidence in the record. There is a reasonable likelihood of a specific unreasonable impact. The runoff thing, I mean, it's a stalemate for me on that question. I don't think we've cited a specific unreasonable impact to the environment.
So I'd like to try to move to a motion in a few minutes. Bob?
Just what I said at the beginning, I don't agree with the seating for this session.
Understood.
Is it possible for me to state my opinion about the situation? I said, if you don't think so, fine, but I...
Bob, give me 1 minute on that. Nick?
Yes, sir.
So we have an alternate that wants to give his opinion on the things that are being discussed. He's not seated. I've been in TPC meetings in Woodbridge where we have done that, and TPC meetings in Woodbridge where we have not. I would like to hear what he has to say. Do I have to motion that, or is that something I can't even do? Can you just help me out on that?
You can allow it as the chair. There's no
Thank you.
legal.
Hold on.
I mean, the chair can make the call. My legal recommendation is to only take comments from those who are seated and actually rendering a vote. That's how I consistently advise my clients.
Okay.
It's up to you, Mr. Chairman.
Okay, I'm going to take town council's advice. Sorry, Bob. Okay. All right, so with all of that said, anyone have any more comments or questions that they want to say before we move to a motion?
Mr. Chair, can I just touch on one thing that's
Please.
changed? So I just want to make sure, because there's a few things that have changed in the motion that's in front of you from last week, or 2 weeks ago, or however long ago. And
So we have a motion to deny and a motion to approve.
correct, yep.
All right.
And so there are portions of the motion which you'll see highlighted and bolded to just sort of reflect what was changed. So since you guys were having discussions about stormwater, I wanted to touch on it because that's some of the things that have changed.
Yep.
So one of the conditions which existed and is remaining is that the applicant has to provide certification from their engineer that the drainage has been installed in accordance with the plans before we would release the initial bonding for the project.
Okay.
So, there's temporary work that will be done, temporary E&S when the project is under construction, but before we're gonna give them a certificate of compliance, their engineer will certify that all of that retention in the ground and the renovation, all that stuff that's there, has been installed in accordance with the plans. I also added, at the bottom, it's condition 27, 1 year after the issuance of the certificate of zoning compliance, the applicant's engineer shall provide the land use department with an inspection report covering all stormwater infrastructure to demonstrate all system components are operating as designed. So you guys had a discussion at the last meeting about some of this, and you heard a lot of testimony sort of for and against, and you sort of impressed upon me that to some extent there's a lot of faith being placed on the functionality and design of a system, which does not exist and none of us fully understand except a few people who are in the room. So, well-designed plan or poorly designed plan is only half of it, right? It has to be constructed correctly.
Yes.
And so I have done this in other projects where you have some type of monitoring so that it's great, everything looks good when it's first installed, but after it gets covered up and everybody goes away, well, what happens? So by requiring that they provide the reports to us, will give us an opportunity to then provide it to town engineer, and they'll be able to review so that all of that treatment that they're suggesting is gonna happen by these systems is actually occurring. So if that turns out that it's not functioning, and that treatment of that water isn't happening, well, then they're not in compliance with their approval, right? So we're trying to address this issue of sort of ongoing compliance so that we can demonstrate that the project was constructed and is functioning correctly. Does it seem to me like that was something you discussed at least the
I
last
think that,
meeting?
and I appreciate that as well. I think the challenge is, look, and there really is no solution, because 1 year is such a small piece in what could be some storm in 2 years or 5 years or 10 years. I've been here for 59 years. Sometimes you go a decade without one of those monster storms. Then when it comes, I've been here when the other side of Litchfield Turnpike flooded and residents were stuck. Took a long time to change that. But I appreciate this very much. I just don't think, and I don't think there's a way to satisfy me in that regard, because I think 1 year or 15 months or 18 months is just not going to be sufficient to know what's coming down.
This was more to get at quality, water quality, not necessarily
I'm sorry.
quantity.
I thought you meant-
I mean, it
okay.
satisfies both, they're designing this, and, they told you and the engineers reviewed for, whatever year storm, right? They designed beyond capacity. But there was a comment that was made about really like, they don't even know what water their site's already receiving, what it's coming off the Merritt, and what that looks like, but there's gonna be some renovation of the water once it goes into the system that they proposed. That's all well and good, but we wanna actually know that it's
understand.
functioning. So this was really meant to deal more with quality, but I
Yeah,
hear you.
thank you.
Is 1 year sufficient to allow, like, plantings that they will have to, I'm just wondering if it's, if it's 18 months or, there's effects of the grass that they're gonna plant or the trees they're gonna plant on stormwater, and is 1 year the, sort of standard that you see in this type of language?
I think, there's a lot of things that go into something like this and wanting some type of ongoing monitoring. There will be ongoing maintenance and a maintenance plan for those structures regardless of anything that we say. So I had kind of kicked around some language for this as far as, when is the certificate of zoning compliance issued? Because if they get an approval and they build the project and they say, we're ready to go and it's November, and we're not gonna have them do the plantings, right? We're gonna say, wait. So there could be that period of time. But I couldn't come up with an alternative sort of language that was well-defined. If if my suggestion would be that if you're not sure, based on there being some leeway with the planting season, make it 2 years.
I'm open to your suggestion, I just want.
I hear what you're saying as far as there's some establishment of the ground cover and a lot of these other things, which if it's in a state of flux, once the certificate is issued, that could have some of those impacts, and you're right. But exactly how long will depend on variables we don't know now. So I would say, making it 2 years, obviously would cover whatever that delta is in that winter.
If anyone is interested in offering their opinion on mine?
Well, I mean, if we have a concern about, you're not being adequate, there's certainly nothing to say we couldn't specify more than one time point. Is that correct? We could say 1 year and 5 years, 1 year and 50 years. every year, every 6 months.
I don't know that you want to get a little bit, yeah, you don't want to be so extreme, but I guess the thing that I would say is it likely going to be good at 1 year and bad at 2 years or 5 years? You know, if the more established the site becomes, the more likely the results are going to be positive. So that initial test is the most likely to show issues, because if the site is still not fully stabilized.
So that's a good point. And then obviously if like trees die, it gets worse, Lynn, so having it at the beginning is, yeah, that's it.
I mean, you know, one of the things that Mr. Trink has pointed out was these deep, oh God, I don't even know what these things are. These deep underground stormwater detention and treatment systems have a maintenance interval of 6 to 12 months. I'm just curious if we need to allow that cycle to, you know, fully occur. I have no problem whatsoever with 1 year, but
We can just keep it at 1.
yeah.
All right, any final comments before we move to a motion? I motion to approve. So looking for a second.
Approved with all of these conditions as set forth by...
Yes, what will happen, Ben, is I'm going to do motion to approve. If I get a second, we're going to spend time discussing it and going through all the various points that are in the motion before we go to a vote.
Second.
All right, so any discussion, which is where we are now? It just means that we have a motion to approve on the table. It's not approved or denied, it's just a motion to approve. It's on the table.
And
People, go right ahead. Yeah.
Sorry, approve what? Because don't we have...
So we have in front of the commission a detailed motion for consideration for approving said.
Jeff, you can just simplify it and say you move to approve the applicant as stated by whomever, by Attorney Belmonte or...
I can, Paul, I just want to see if anyone wants to add anything to it, but thank you.
But you can't...
Mr. Schatz, thank you.
Right, so once the motion's made and seconded, you can't, someone need to amend it, you can't. You have a motion on the floor, you have to discuss it and then vote on it.
Yes, but Nick, can we amend this motion
Yes,
during discussion, right?
you can amend it.
Yes, so I think the motion to approve that's currently on the floor for discussion prompts the discussion, and I don't think there needs to be a subsequent amendment in order to effectuate the conditions that are in front of you. I think the discussion is a motion to improve, and then ultimately, if this commission is aligned in the motion to approve consistent with the staff recommended conditions, that should just be recited again as the final motion, and you can call a vote.
Right. You don't need to read the whole thing unless people want to read it on the record. But
No, I'm not planning to read the whole thing.
Is there, are there any of the 27, is there any specific discussion? We've already, prior to the motion, discussed the number 27. Does anyone have any discussion of any of the other points in this motion
That's right.
that anyone wants to modify in the language?
I just want to make sure I understand. This are the three, aren't there 3 items before us?
Yes.
There's the construction, there's the roof modification, and then there's the excavation, removal, filling, grading, and processing. That's correct, right?
Yes.
That's primarily what I was asking.
Yes, and those items are in the agenda for this evening, they're spelled out. And those are the 3 items that are applications for: special permit for excavation and removal, special exception site plan to construct the development, and then a special exception to modify the requirement for the roof, all of which is spelled out in the motions to consider, including the motion to approve, which is presently on the table. Michael? A couple of points in the motion say may. Point number 23, the commission may require an additional landscape establishment bond based upon the timing such landscaping is installed or the time of year the certificate of the compliance is requested. Can you put well?
What?
Just in a,
Sorry, that would be if we suspect that they're gonna plant the trees and the grass and then
so you
it's
want
gonna die immediately.
So you want to just keep it may?
There are, in my opinion, reasons why it wouldn't, I mean, it's just money to the developer, but there's reasons why they wouldn't be necessary, in my opinion, because it's the time of year when I don't know, what, would you like to?
So if a situation came up where the erosion and sedimentation control bond that we would get at the front end of the project wasn't in place, all that had been taken care of, and there was plantings that were done sort of outside the recommended time of year when those individual plants were done, or if, something freak happened with the weather and so we were worried that that establishment just wasn't gonna happen, then yeah, we would make a determination at that point that we wanted to hold those so that the necessary landscaping would essentially survive. And that could be through winter or through, the dry part of the season. But if the project sequence happens sort of as intended, not just the perfect world, then those plantings would be done at the time as recommended based on whatever they are, trees, shrubs, etc. And so if they're planted when they're supposed to be, then they wouldn't.
Then there's not an issue.
Correct. But as your staff, I want to be able to tell the applicant, we're not comfortable based on when those went in, and so you're going to financially guarantee it,
Okay.
just in case.
Anybody else?
Yeah, I just want to say, I can read the tea leaves here, as everybody else in the room can read the tea leaves.
Yes.
I just believe we are completely abdicating our responsibility to the community of Woodbridge.
Can you articulate why, Jim?
Yeah, it's all the reasons that I've said, Ben, and that you've dismissed, and I respect your opinion. But I think that it's for all the reasons that I stated. I think that we have a responsibility to the community at large. This building doesn't satisfy the requirements for the community at large. It doesn't, in terms of the overall environment, in terms of safety, a 4-story building with that you're going to see every car that goes back and forth on the parkway, that's going to be Woodbridge. It's going to be a flat-roofed building. When you look at the elegant buildings that are down at Yale or almost any university that have lasted for a long time and are a statement about the quality of the community, there are pitched roofs. The fact that we have a flat roof, that we're going to grant this exception so they can have a flat roof, I think it diminishes the appearance, the character, the quality of the area. We're putting in a flat roof so that we can have 96 fire hazards up on the roof. That's why we're doing this. And we're going to do it at the expense of our firefighters, to their safety, and at the expense of the tenants in the building, and at the character and the nature of the neighborhood. I think we're just making a huge mistake. On the question of the stone, the rock, you can dismiss the report of the intervener and say, well, I'm just not completely persuaded. We don't have to be completely persuaded. Look, and in terms of a legal process, they're always close calls. But you have to make decisions in close calls. And you've got a report that says there's water hazards, there's drainage hazards, there's environmental hazards. And we say, well, they can fix all those things, but that's not our job. Our job is to say, look, we need to protect the community, we need to protect the safety of the area, and we should be giving credit to the intervener's engineering report that says, look, this stuff is all dangerous. Yes, you can dismiss it all. I can see the tea leaves. You're going to dismiss it all. On the question of the affordability, when those look, the affordable housing requires us to have a certain percentage of affordable housing. That's what the affordability is. If we get a percentage of 10%, that's a home run. if we get a percentage, I believe it's of 2%, we have a moratorium, and we have 4 years where we don't have to have more affordable housing. What happens? What happens when their number takes us under 4% and we're now at 1.96%? That benefit that we got from the affordable housing hiatus, we've now lost that, or arguably have lost that. I don't know that it's been litigated, but you don't know that that's been litigated. And so that makes me worried that we're getting some protection that's ephemeral, it's mythical. And we're completely dismissing the reports of the environmentalists and the engineers that were hired by the interveners. So I know I'm just saying the same thing I said before. I know you're going to dismiss it because you don't agree with it. I know you're going to say that it's not persuasive enough. It doesn't have to be persuasive. In these kinds of settings, in legal world, the standard isn't this, beyond a reasonable doubt. That's a criminal standard. We're not in criminal standard world. More likely than not. That's all we have to decide. And look, if we don't satisfy our requirement, Mr. Neff is going to go and he's going to take it to a judge. And a judge will say, yeah, you did it, or no, you didn't do it. But we should have the courage to say that what we're doing here is to protect the community, and if there's a lawsuit that's filed and some judge comes along and says, you know what, you didn't satisfy your obligation, great, we didn't satisfy our obligation, let's move on. But maybe we did satisfy our obligation, and that's why we have good lawyers, and that's why there are good lawyers out there. And we should not be afraid to fight the fight to protect the town, because once those rocks are gone, and the trees are gone, and that 4-story building with the crappy flat roof and the 96 fire hazards is there, it's there. It's there, and that's our legacy to the town of Woodbridge, and I think we're just making a huge, huge mistake.
I just don't think that, I don't think it's accurate, and I don't think it's particularly respectful to characterize, my assessment of, the available information as dismissing. I use that word so many times. Dismiss, dismiss, dismiss. I'm not dismissing anything. I'm trying to understand what our role is in this process and conduct myself accordingly. I do not think it is our role to be the, quote, saviors of Woodbridge, to just fight in a general sense for the town. I think that if you want to point to an error, if you feel that this whole thing was misconceived, you have to go back to the zoning regulations. But we're operating under the zoning regulations that we adopted, in December of 2024. And I'm not operating on a reasonable, beyond a reasonable doubt standard. It's the threshold that we have to be able to articulate to get to a denial. I mean, am I misconstruing that or misconstructing it in your view?
So I apologize if you think that I'm engaging in some ad hominem attack. That is not my intention. I disagree with the conclusion that you're reaching, but that is not to say that I disrespect you. So please understand that. I believe that we have ample evidence and ample support in our regulations to say we should not be approving this. If you just go to 1.0, and 1.2 is the purpose, that here is why we exist. This is our raison d'etre. The use of land in accordance with a comprehensive plan, to lessen congestion in the streets, to secure safety from fire, panic, and other dangers, to promote health and general welfare. These are our obligations. This is our commitment. When these kinds of things are put into regulations and they're put there as rule number 1, this is the overriding theme, the overriding essence of what it is that we should be doing. And then when you look at other places in the regulations, it supports the same thing. So use that as the backdrop, that's the backdrop for what it is that we're doing. And when you look at the landscape standards, to the maximum extent possible, existing trees, vegetation, site features such as stone walls, boulders, or rocks, outcroppings, shall be retained and protected. In lawyer world, there is no more powerful word than shall. They could have said will be protected, might be protected, could be protected, should be balanced. There should be a system of protect. That's not what the regulations say.
You're drawing this from site amenities. It's talking about how we consider a specific site. This is not a general statement about the entire town.
No, I agree with you. So let's talk about this site. To the maximum extent possible, rock outcroppings, all those rock outcroppings, 100 yards of them that stand 30 feet tall, those rock outcroppings shall be retained and protected. We speak for the rocks.
How do you interpret the word possible in this context?
To the maximum extent possible.
Possible.
That's right. That's saying possible is different from the word probable. Possible means if there is a potential impact that you could have, that is a possibility. A probability is it will have an impact. Possibility is actually, this is a lower standard for us to act to protect the rocks and the trees. This isn't a higher standard. This says that if there is a potential threat to rocks, to trees, to the environment, to vegetation, to stone walls, to boulders, to rock outcroppings, it is our job, like in the Lorax, to speak for the trees. That's us.
The way that
That's us.
the way that you are articulating this particular argument would completely preclude any development whatsoever of undeveloped land.
I don't agree with that, but again,
Can you explain to me how? You just use this maximalist interpretation of this phrase. How could you defend any development using the interpretation that you just promoted?
so let's say you were to take this same building and you were to put it on the field that's adjacent to the JCC. The old tennis courts, I don't know the name of that field down
Yes,
there.
sure.
You know which one I'm talking about.
I vaguely understand.
Okay. Rocks there?
I don't know the site well.
It's flat. Trees?
So, are there rocks or trees? There are rocks in the ground. There's grass. You used the word grass in a previous statement. You used the word grass.
No, I didn't. But okay. I don't think that I did. If I did, I misspoke because I'm just reading from it. To the maximum extent possible, existing trees, vegetations, site features such as stone walls, boulders, rock outcroppings shall be retained and protected. I agree with you, on the site.
And how did the field that you're describing come to be?
You know what? I don't know the answer to that question, but we are where we are. But we are where
Jim,
we
can
are.
I ask a question? So you brought up the point about general welfare. So does that go to the town as a whole? Because, well, let me take you where I'm trying to go. So general welfare of the town. So in Woodbridge, we have an insufficient amount of housing for our older citizens if they want to downsize from a large house. So we don't have as many options for them to stay in town. And we don't have as many options in town for the children of parents that live here to rent in town. We have like very few options, all right? You have to, generally buy a larger house, or you have to, if you downsize and you want to have you want maybe to live in an apartment, okay? Or if you're 26 years old, you're unmarried, and you have like, your parents live in Woodbridge, okay? There's not a lot of housing options for these folks. So let me ask you, does that attach at all to the general welfare language in the regs? I mean,
So does that mean?
It goes to the use of this particular application.
So does that mean that anybody who's building a large piece of property
Sure.
that's going to allow for grandma and grandpa to stay in Woodbridge,
Yeah.
that we have to say yes to that?
No.
And the answer that I would agree with you. The answer is no.
No.
There are going to be some projects of some size, of some magnitude, in some location,
Yeah.
where it makes perfect sense to build something that's going to allow people to stay. That's going to satisfy our obligations with regard to having 10% of our housing be affordable housing. I think that that's right. Whether this is a project that if you moved it to a different location, it could satisfy those requirements, I suspect that the answer is yes. But in this location, where you run the risk of draining Bishop's Pond, flooding the people downstream, endangering our firefighters, creating an ugly building that's going to be there for 40 years, taking away natural resource of the outcropping and creating affordable housing that doesn't even necessarily satisfy our obligation under the affordable housing rules to give us the benefit of not being required to build our 10% of affordable housing in the next 2 years or 4 years. We don't have that protection from this plan. It seems to me that when you put all of those things together in a box, that this is the wrong, maybe it's a good building, but it's the wrong place for this building. And that's our job to say that. It's the wrong place for this building. And I'm not going to say, look, I know where you all are.
We're listening. We're listening.
All right. I'm repeating myself at this point.
It's been, you were in dialogue, so I want to give you, I have something else to say, but if you have, I don't want to cut you off if you were.
No, I just really want to understand, how we're arriving at our conclusion, because I think it's important in both directions.
Going back to the clauses of the motion, we had a discussion last week with the fire chief, about possible storage of the ladder on site. And I don't know if you were in the meeting. The fire chief said that their current truck can't hold the ladder because it's too long, and that they have the ladder truck, which has been delighting my children driving around town, is a 92 model, and they're in the process of working, but it takes a long time. And so to get a new one, which may be able to hold that, and there was discussion of maybe they could, the negotiation with the developer to identify a way to, in a climate controlled and out of the weather area, store the ladder. Is there a way that you can think of to encapsulate that in a 9.2 or in 9 or something,
So I think that my recollection is that there was some pretty clear comments made during that discussion by the applicant that they're more than happy to work with the fire department to identify appropriate storage. So that's there and that's not going away. Yes, you could absolutely add even to the tail end of 9, so that it clarified that. You could, so it currently reads, the applicant shall purchase a ground ladder to be provided to the Woodbridge Fire Department, which complies with NFA 1931 and is of sufficient length to reach the fourth floor windows. And could add
something like work with the applicant to identify an applicant shall construct the necessary reasonable accommodations.
and shall provide acceptable, should provide on-site storage acceptable to the Woodbridge Fire Department.
Adding a reasonableness in or something like that.
Can I just point out that on that point, the fire chief also said that the ladders that they currently use, and if we do keep pointing out, we have a volunteer fire department, and he pointed out that the ladders that we currently use can be handled by 4 firefighters, and that this ladder is now going to be required to be handled by 6 firefighters. And this is a volunteer fire department where we are going to be creating an additional burden to get more people at the scene before we can safely get to the top of this 4-story building to get to these 96 fire hazards.
I wish we had had more, sort of designated discussion with the fire chief, because I really value, his expertise and his opinion, and I tried to elicit it in different ways, throughout this process. I'm trying to find out how many air handler fires there are annually in the United States per year. Are we somewhat over are we somewhat overdoing it by identifying these air handlers as fire hazards? It's an electric pole.
There's a degree of hyperbole in there, but you have 96 machines up there, and You know, I worked in a building in Bridgeport for 30 years. They had air handlers up there. There were all kinds of electrical problems that happened over the course of 30 years with air handling. It happens. It happens. You know, do I know the statistic? No. Did they address the statistic? No. Did the applicant give us the statistic? No. Did the applicant talk about the fire hazard up there? No.
I mean, it doesn't sound to me like you're making the argument that that's unreasonably unsafe. It sounds to me like you're making the argument that this is a place where our volunteer fire department may need to get, right? And I certainly accept that. I mean, does anyone have, Paul, do you recall the fire chief's sort of?
It's an area of, I'm sorry, you were just.
Yeah, no, I mean.
It's clearly, the fire department needs to be able to get access to the roof because there are electrical connections and it's, you know. And so the applicant's lowering of the parapet is, I think, seemed to satisfy, my opinion was it satisfied the fire chief. You know, there will be, you know, we have this building, there may be other buildings in the town. We have, it's hard for me how to weigh, because we have a state building code and fire code that governs how these things are built. And then we have local fire officials and we have a volunteer fire department, and they are an unbelievable asset to the town. And so, but we should, and as a board, we don't have a lot of control over this, but if we as a board are looking to increase development in the town, whether it's commercial or residential development, we should have a process in place to work with the volunteer fire department to make sure that they get the resources that they need to be able to do that. I mean, everyone talks about wanting more development in the commercial down in the flats. That seems to have been a bipartisan thing. And so the question is, you know, what if Stu Leonard's decided they didn't want to be in Orange or Milford, but they, you know, wanted to be at, take over the Nevco space. And that's a big grocery store, and do we have, that's a different animal. Is that, how do we, I do appreciate that comments from the public, but also we sat and we listened respectfully to all of your comments. And so throughout this past 12 months, it's harder for us to have this conversation.
So all this isn't relevant to the motion on the floor, though.
Well, people are concerned about the fire.
Right, but I mean, there's a motion on the floor, we should
No.
discuss the motion and either vote yay or nay,
Yeah.
or amend the motion and move on, but I think we're in this like,
I think it's relevant.
I think Ben is working through his opinion on this, and I like talking through it with him.
The reason I think it's relevant is that the you know, general welfare and public safety are certainly things we have to consider. It's part of the reason that we were asking all these questions about fire safety and about the parapets and about the elevators and about the ladder. And you know, the fire chief did make a general statement that we don't have the infrastructure in the town of Woodbridge to, and I don't want to mischaracterize what he said, but he said something like, we just can't take care of a 4-story building. And again, I don't recall his exact words, right? But there was a general statement to that effect. Again, that is something that we should have considered, that should have been part of the record and the public hearing when we made the zoning regulation change that allowed for 4 stories. I mean, you can tell that I'm deeply troubled about how that all unraveled, but you know, we are here now, and you know, as you said, Jim, we are here under the zoning regulations that we changed. So, you know, can we use as a basis for disqualification the fact that it's a 4-story building? Because our fire chief said he couldn't fight a 4-story fire in a 4-story building, but we created regs that said we could build a 4-story building in town. I'm struggling with that.
I would just want to reiterate that, you know, they're not going to get a building, the building department is not going to issue a building permit if it's not in compliance with the Connecticut State Fire Safety Code. So, we're talking about, this application is on land use, and if the building is not safe and it's not compliant with the state fire safety code, then they're not gonna get a building permit.
Well, but, yeah, yes, I agree, and I think that that's correct. And if we're thinking about public safety and the ability for the fire department to perform their professional duties there, now we're talking about, are we then, have we, the Planning and Zoning Commission, committed the town of Woodbridge to buying that new truck or buying the equipment? I mean, I Googled it last meeting, those trucks are $1 to $2 million, right? We talked about what has to happen for the school. I mean, I think it doesn't directly speak to the qualities of the application, but I think it's within our larger consideration of public safety. Is allowing this development to proceed going to be consistent with the general welfare and public safety based on incomplete information from the fire department? Not an insult to the fire department, but more sort of like a frustration with this process that the fire chief wasn't like at all the meetings and like answering these questions at every step along the way and giving us many more details about why they can't fight, fire in a 4-story building. I'm not saying that that's not true, but what are we on the hook for?
And I would just go back and point out what our regs say. And at 1.2, purpose, the raison d'etre. Why are we here? We are here to secure safety from fire, panic, and other dangers, to promote health and the general welfare. That's our job.
Yeah, I mean, I think that if we just attempted to follow those principles without thinking about the inevitable need for development and building, then the most rational way to promote those principles, or the surest way to promote those principles, would just say, we're just done building in this town. We're just not going to have any new building or new development.
Yeah. I'm not sure that follows, but I hear what you're saying.
So I think we've had quite a bit of discussion. I'm going to move to a final vote on the motion on the table, which is, I think, the right thing to do.
Were there any modifications that we put in? Can we summarize any modifications that we added? Was it simply was there an amendment to .9? No. It was just,
We talked about one, I don't know where you might have
made, no.
I'd like to propose an amendment
just
to .9 based on the language that town planner stated.
And then after we deal with the amendment, could we have a 5-minute recess before we move to the final vote, Mr. Chairman?
Which one is vote?
I think we can just vote and, yeah. All right, so number 9, you okay with that? I didn't.
Do you want me to read it?
Yeah,
Yes,
reread
yeah.
that.
The applicant shall purchase a ground ladder to be provided to the Woodbridge Fire Department, which complies with NFA 1931 and is of sufficient length to reach the 4th floor windows, and shall provide on-site storage acceptable to the Woodbridge Fire Department.
All right. It just doesn't sit quite right that was never really hammered out, shall provide on-site storage. I mean, is that what the fire department wants? If they get the truck, do they want to tote that ladder around with them?
I mean, they can take it. That's the thing. It's shall provide the storage. It doesn't, in my
Doesn't say
opinion, it
where.
doesn't
I mean, they can go
require
back.
the fire department to
Okay.
leave the
enough.
fire department owns the ladder and has to agree to how I envision that being read, and you can tell me if is that, they have to work with the applicant to identify somewhere that the ladder can securely and safely be stored. And if the fire department would like to avail themselves of it, it's the fire department's ladder. And if they have want to attach it to their truck by any means that they deem reasonable, then they can do that too. It's just kind of a belt and suspenders, because that was, a very valid point brought up by the fire chief.
What if I changed it to, and shall facilitate storage in a manner acceptable to? So if the fire department determines that acceptable storage is at the firehouse,
Yeah.
it doesn't obligate them to keep it on site if the fire department chooses. There may be another building, I don't know, I don't want the fire department to be restricted to using it.
Yeah, I
So
don't-
this frees it up a
That's
little?
fine, yeah.
Yeah, probably the original wording would have been fine under your explanation, Aaron.
But no, that's either way, I think the, as modified is fine as well. It gives the fire department leeway to decide.
Any more changes, suggested changes?
Jeff, you have to decide if you're going to accept his amendment.
I accept it.
Okay, and then who seconded the?
Motion to accept the amendment?
No. So who seconded the original
Kat.
motion?
I did.
So you have to decide, you're good? So now we have to vote on the amendment first. You have to vote on the amendment, then go back to the motion.
All right, all in favor of the amendment as proposed, first and second, say aye.
Aye.
Aye. Amendment, please include it in the motions, we're back to the
Now you
motion.
revert
All
back.
opposed.
Oh, all opposed, I'm sorry.
Thank you.
Thank you.
Now you.
Do you have that, do you have that, there was opposition, a no
I-
on the amendment?
I would really like you to individually vote on this so that I can see who voted.
Let's go again.
Okay?
Okay, all those in favor to the motion on the floor?
No, to the amendment.
To the amendment on the floor, in favor of making the change with the fire truck ladder, raise your hand. So,
Thank you.
any opposed? Any abstentions? Chris, we good?
You're good.
Thank you. All right,
Now
so,
you're voting on the big motion.
so on the big motion, all those in favor say aye.
Now raise your
Wait,
hand so she can count it.
What, say that?
Raise your hand.
Raise your hands, raise your hands.
The big motion is to approve.
Yeah.
Yes, the motion is to approve, yeah. If you're in favor, say aye or raise your hand. Those voting against the motion? Any abstentions? Motion's carried.
You gonna adjourn?
Want a motion to adjourn?
Mr. Schatz?
Move
I think
to
we're
adjourn.
completed. Second?
Second.
All in favor?
Aye.